Thank you very much. Thank you for the organizers to invite me and give me the possibility to talk to you about the role of the agent, which is a unique situation in my life. And thank you very much for finding this beautiful place for the event. It is a very good day and a very good year because it is a 70 and a 30 year celebration for us. As it was mentioned by the Deputy Minister that we celebrate the accession of the Republic of Hungary to the Convention of European Convention of Human Rights. The date of the accession is 1992, but the act concerning the accession was promulgated by the Hungarian legislation in 1993 in September. So it's a good day for us. The first judgment, as it was mentioned by Mr. Pacolai, who is the Hungarian judge, as you know, this judgment was delivered by the court in 1999. It was the first court judgment, and since then we have 646 judgments, 646 Hungarian judgments, and now we have 622 cases before the court. Only some statistical numbers. My perspective is the perspective of the agent before the European Court of Human Rights, and I would like to introduce the agency itself. The agency is the unit which represents the government of Hungary before the proceedings before the European Court of Human Rights. The agency was established in 1994, 1 year after the act was promulgated and became the part of the Hungarian legal system. It was a dilemma where to establish this agency. In some countries, the agency works within the structure of the Ministry of Foreign Affairs. In some countries, this agency works within the structure of the Ministry of Justice. And finally, the decision of the government was that this topic is a legal topic, not a political or a diplomatic issue, a legal topic. And that's why the decision was that it is necessary to establish this agency within the structure of the Ministry of Justice. And I think so that it was a very good and a very reasonable decision. Our activity is very complex because on the one hand we represent the state before the European Court of Human Rights procedures, but also during the execution phase before the Committee of Ministers as well. During this activity, we have to coordinate with other state agencies and other organs, state organs, courts, public prosecutors, and so on and so on. And we have a very little unit for it. The agency means that there is one agent, myself and my colleagues who are sitting here, some of them, and only 6 lawyers works for this unit, but we try to do what we can, and we have good experiences as well, not only bad experiences. If we take my point of view, and I try to introduce my perspectives. First of all, I would like to mention that when I joined the agency, it was in 1998. Only very few of cases were before the court in connection with Hungary. Perhaps 10 or 12 cases were before the court. It was in 1998. And after then, we realized that we have an increasing number of cases, an increasing number of Hungarian cases. We try to find the cause of this phenomenon, and we realized that one important thing is the language regime of the court. The applicants can submit the applications in Hungarian as well. It's a very good possibility for those citizens who cannot speak English, French, or another language, and it's a very good possibility for an ordinary citizen to submit an application before the court. Another important factor is that the legal representation is not obligatory, which means that it is not necessary to pay the lawyers a lot of money if it is not necessary. It's a very important aspect. It is said by the applicants who...
That you are in front of lawyers.
Yes, it's a dangerous position, but to tell the truth, it's very important for these ordinary citizens. But you are absolutely right that it's a very, very, very special situation. The third aspect is that it is a very, very, not very costly possibility. It is not necessary to pay any fee. And it is a free possibility, we can say, to introduce an application. And the fourth factor is that the applicants are more and more familiar with the convention. There are a lot of news on the internet. Books were published in connection with the case law of the European Court of Human Rights, and the people are more and more familiar with the content of the convention. Our challenges, or biggest challenge is how to manage this number of cases and this huge number of cases. It is the biggest challenge in our activity. To tell the truth, we have a good possibility to manage these cases, the so-called friendly settlement proceeding. In the so-called well-established case law cases, for instance, lengths of proceedings cases, it is possible to make a friendly settlement with the applicants. It can accelerate the proceedings. So it's a good possibility for the state agent to manage the case as quickly as possible. But it is a possibility for a limited number of cases. It is also a very important challenge in our activity that we have to manage the execution of the judgments. And in connection with the execution, we have to organize the payment of thousands of cases, which is not an easy thing to collect the bank account numbers and to deal with the applicants all the deals in connection with how to pay the just satisfaction and where to pay the just satisfaction. So it is a very important part of our duty as well. As I mentioned, there are a lot of practical problems or practical challenges in the activity of the agent. I can mention to you that the biggest challenges in our activity were two so-called pilot judgments. Hungary has had two pilot judgments till now, one in connection with the length of proceedings cases and one in connection with the prison overcrowding. The first pilot judgment was the so-called length of proceedings pilot judgment, two judgments, one in Barta and Drajko in 2013, and one in Gazsó. It is the name of the group of cases, Gazsó versus Hungary from 2015. According to these judgments, the government had to introduce an effective domestic remedy in order to help the court not to deal with the thousands of cases and to make it possible to deal with these problems, the problem of the length of proceedings within the structure of the Hungarian legal system. It was a long proceeding because the first judgment was in 2013, as I mentioned, the second in 2015, and after the next years, the Hungarian state tried to find a good solution in connection with the introduction of a domestic remedy. Finally, the parliament could pass a bill in connection with the length of civil proceedings, the civil length cases, what we can say, and this act entered into force on the 1st of January 2022. After the first 1.5 years, the court tried to find a solution in connection with the effectiveness of the domestic remedy of this possibility. In the Saxon versus Hungary case in 2023, now on the 13th of March, the court finally decided that this remedy is an effective remedy. So it is not necessary to go to the Strasbourg forum. It is possible to use this remedy within the structure of the Hungarian legal system. But to tell the truth, we have a very interesting sentence in the Saxon judgment. It is the following: the practice of the domestic authorities can show in the long run that domestic cases in compliance with the requirements of the convention. So we are waiting for the practice of the Hungarian domestic courts. If the domestic courts can do their job in a good way, we can keep this domestic remedy in line, and we will be successful in connection with these cases. It is a very big advantage that almost all the civil cases are under the jurisdiction of this act. Not all the civil cases, only the contentious cases. The non-contentious contentious cases are outside the scope of the legislation. And we have to solve the problem of the criminal cases and the administrative cases as well, because in connection with the criminal and administrative proceedings, we have no domestic remedies right now. So it is the challenge how to manage these cases in the future. The other type of, or the other pilot judgment was the so-called Varga and others judgment in connection with the prison overcrowding cases. To tell the truth, the first prison overcrowding judgment was delivered by the court in Szél contra or Szél versus Hungary case, and after then the Kovács István Gábor versus Hungary and the Varga and others versus Hungary judgments were delivered by the courts. Between 2012 and 2015, 4 judgments were delivered, and the court found that having regard, I try to quote it, having regard to the circumstances of the applicants' cases and their cumulative effect on them, the court considers that the distress and hardship endured by the applicants exceeded the unavoidable level of suffering inherent in detention and went beyond the threshold of severity under Article 3. Therefore, there had been a violation of Article 3 of the Convention. It was a very good news for the inmates, to tell the truth. In 2016, 2015, and 2016, about 18,000 inmates were in the Hungarian prisons, which means that all of them had the possibility to submit an application to the court. And this possibility was realized by the lawyers as well. Some of the lawyers who realized that the chance is fantastic. In some cases, the court delivered the judgment and gave about 25,000 euros for the applicants, which is a huge number of money. Or amount of money. In some cases, this amount was only 2,000 or 3,000, but it was a sum which didn't need a very comprehensive and a very complicated activity of the lawyer, to tell the truth. It was very clear that it is a possibility for the applicants and for the lawyers to manage these cases before the court. Within 1 year, almost 9,000 applications were submitted to the court, and the Hungarian government realized that it is a very dangerous direction, and it would have been possible to pay milliards of forints for these applicants if the government or the parliament cannot or couldn't find a good solution. After 1 year, a domestic remedy was introduced with the coordination of the Ministry of Interior and with the coordination of the agency as well. And the court was very quick. And in November 2017, the Domjan decision was delivered by the court, and according to the Domjan decision, this new domestic remedy was found effective. So after this period, these inmates couldn't went to the Strasbourg court. Now they have a possibility to challenge these cases before the Hungarian domestic courts. And it's very good for us. We do not have to deal with these cases. It is good for the court, yes. It is good for the court as well, because the colleagues from Strasbourg mentioned that I don't know, they hadn't have enough place in the rooms. They had only case files everywhere. So the situation is now much better. To tell the truth, we have challenges before us as well, because in connection the pre-trial detention case, we have similar problems. There are hundreds of pre-trial detention cases. Only some words about it. In pre-trial detention cases, there are two problems. One of them is the length of detention. After 1 year or 1.5 years, detention is lengthy, according to the case law of the European Court of Human Rights. On the other hand, it is very important to make detailed reasoning of the decision, and sometimes the judges haven't have enough time or resources to do it, and the detailed reasoning is also a problem in connection with the point of view of the court. We haven't have a pilot judgment yet, but we are afraid of it, that it is a structural problem. We have hundreds of cases before the court, so we have to do something in order to manage this situation as soon as possible. I would like to tell you some words about. I have some time. I hope so. Some minutes. I would like to tell to you some words about our activity before the Committee of Ministers proceedings. As I mentioned, we represent the state in connection with the execution phase of the judgments, which means that the government and the agency has to submit action plans and action reports to the Committee of Ministers in connection with the execution of the various cases, of the various judgments. We have to submit updated information to the Committee of Ministers, to the Council of Europe, and to tell the truth, we have a lot of pending cases before the Committee of Ministers. There are 4 meetings of the Committee of Ministers, CMDH, for every year, and in the last year we realized that in the autumn, in the winter, in the spring, and in the summer period, we are always on the agenda. So we have to solve these problems parallel with the court proceedings as well. What the biggest challenge of the agency is? If we take this question, we can answer that the management of the cases and the management of the huge number of cases. How can we do it better? The first aspect is that we have to have good colleagues, what I have. Another important topic is that we have to coordinate with the other authorities. It is sometimes not a simple and an easy activity, because we have to coordinate these cases not only with ministries, but other authorities, courts, National Judicial Council, and so on, other authorities as well. And we have to have good connections with these authorities. But I have to say that I am a little bit optimistic. The biggest number of cases is the length of proceedings cases, and in connection with these type of cases, we have a good phenomenon, which is Saxon judgment. No, in civil cases we have no communication, only criminal and administrative cases are communicated by the court, and those cases which are not covered by the Hungarian legislation. But I think so that in the future we will be in a better position than before, and we will have more time to manage the real, not mess cases, what I mentioned before, like as pilot judgment cases. So I am optimistic. We have challenges and we will have challenges, but hopefully we can solve it. Thank you very much for your kind attention.